Hello everybody, I am Dr. Bharti, Assistant Professor of Law at National Law University, Delhi. In this discussion, we will discuss National Legal Services Authorities Act, what is the role this act plays in access to justice, and in fact, not only the access to justice, but the equal access to justice. First of all, we need to understand what are the hindrances to access to justice. The major hindrance to access to justice is the poverty of a claimant. Many a times it has been seen when a wrong is done to a person, he is restrained from coming to the court because he doesn't have that much of money to hire the services of an advocate and to pay the court fees. Moreover, if he opt to file a case before a court, then he will have to leave his job or he will have to take off from his job, then he will have to lose his one day's earning. There are many other problems which are creating hindrance in the path of administration of justice, like delay in disposal of dispute. Many a times, and in fact in most of the cases it has been seen, the disposal of cases takes very long. Once a case has been filed, it sometimes goes on and sometimes it even takes generation to get to be concluded. Legal Services Authorities Act was enacted to take care of such problems and to bring the justice at the doorstep of a person. To start with, I would like to say that in this presentation, we would discuss that what are the factors which led to the enactment of this Act, how this Act functions, what are the institutions, what are the bodies which have been constituted under this Act for the implementation of this Act, who are the people who are entitled for free legal aid. Section 12 of this Act provides a list of people who can avail free legal aid under this Act, and free legal aid has a very broad meaning. It includes within its ambit free legal aid by an advocate, which means advocate would be provided to them by the state and they will not have to pay the charges of him. It also includes within its ambit exemption from the payment of court fees. So, this way, if a person is entitled to free legal aid under this Act, he need not to worry about the expenses which he will have to incur to proceed with his case. At the same time, this Act deals with the establishment of and the organization of Lok Adalats. As we discussed, that delay in disposal of dispute also adds to the problem and it makes difficult for the people to get their dispute redressed. So, looking into this problem, this Act provides for organization of Lok Adalat, which is an alternate form of dispute resolution. This is a form of resolution in which parties amicably settle the dispute, they come to a conclusion and court puts its stamp on it. This way, it settles the dispute and as well as it maintains the amicable settlement of dispute. In addition to that, in this presentation, we will also discuss about the permanent Lok Adalat. Many a times it has been seen that when a government is involved in any dispute, when any public authority or public officer is involved in any dispute in which he doesn't have any public interest, such matters are generally dragged for too long because as they don't have personal interest, many a times they fail to appear before the court. And in addition to them, as there are many other duties and responsibilities attached to their post, attached to the seat, so it's not easy for them to take off from their work and to appear before the court again and again. And if they do it, it will affect many other person who comes to their office to get their public function performed. So, all these factors led to the enactment of the Legal Services Authorities Act, and now we move forward to look into the objective of this Act. What is the objective of this Act with which this Act was enacted? The objective of this Act is to constitute Legal Services Authority for providing free and competent legal services to the weaker section of the society, to ensure that opportunity for securing justice were not denied to any citizen by reason of economic disability, to organize Lok Adalat, to ensure that operation of legal system promoted justice on a basis of equal opportunity. The interpretation of this Act in the light of its objective reveals that it is a very good piece of legislation for the amicable and speedy disposal of dispute. The scope of this Act is very wide. It extends to whole of India except the state of Jammu and Kashmir. For the effective implementation of the provision of this Act, different bodies have been set up at different level, that is National Legal Service Authority, State Legal Services Authority and District Legal Services Authority. even at the High Court and the State Court, even at High Court level and the Supreme Court level, different legal service authorities have been constituted, so that if a person has any disputes pending and presented in High Court or Supreme Court, then he need not to go to any other place to seek free legal aid. In the same High Court and the Supreme Court, free legal aid authority is constituted and he can avail the benefits provided under this Act from those authorities. National Legal Service Authority. National Legal Services Authority is the apex body of providing free legal aid in our country. It consists of the Chief Justice of India, who shall be the patron-in-chief, a serving or retired judge of the Supreme Court to be nominated by the President in consultation with the Chief Justice of India, who shall be the executive chairman. Such other members possessing such experience and qualification as may be prescribed by the central government to be nominated by the government in consultation with the Chief Justice of India. Its composition makes it clear that it has members from the legal field as well as from other fields. So, such composition of the National Legal Service Authority makes them in a better position to settle the dispute of the parties amicably, because the members who are from the legal background will understand the legal intricacies of the dispute, and the other members who are from other fields of the life, people who are social workers, people who have more experience of social services, will help the authority in amicable settlement of the dispute. When the task is of amicable settlement of dispute by mediation or conciliation, then people with social background can be more efficient. The tenure of its member is not very long. This provision also puts the check on the monopoly of few people in exercising power under this Act. There are sufficient provisions for one to implement the provision of this Act. These provisions also provide very strict check against the misuse of fund by proper maintaining of account and auditing of these accounts at regular interval of time. Such provision eliminate the chance of corruption in National Legal Services Authority. The functioning of authority are very wide to cover all possible acts necessary for the achievement of the object of the Act. The functioning of the National Legal Services Authority can be summarized as to lay down policies and principles for making legal services available under the provision of this Act, to frame the most effective economic schemes for the purpose of making legal services available under the provision of this Act, to utilize the funds at its disposal and make appropriate allocation of funds to the state authorities and district authorities, to make necessary steps by way of social justice litigation with regard to consumer protection, environmental protection, or any other matter of special concern to the weaker section of the society, and for this purpose give training to social workers in legal skills, to organize legal aid camps, especially in rural area, slum or labor colonies, with the dual purpose of educating the weaker section of society as to their rights, as well as encouraging the settlement of dispute through Lok Adalats. In addition to these functions, National Legal Services Authority also performs many other functions, like to encourage the settlement of dispute by way of negotiation, arbitration and conciliation, to undertake research work so that factors which are creating hindrance the path of administration of justice could be ascertained and their proper solution could be found out, to do all other things necessary for the purpose of ensuring equal access to justice under this Act. Another legal services authority constituted under Legal Service Authorities Act is the Supreme Court Legal Services Authority. The Supreme Court Legal Services Authority impart the facilities provided under this Act to the parties whose dispute is pending before the Supreme Court. The committee shall consist of a sitting judge of the Supreme Court, who shall be the chairman, and such member of other possessing such experience and qualification as may be prescribed by the central government, to be nominated by the Chief Justice of India. Like National Legal Service Authority, it also contains the provision for the appointment of persons from non-legal background, which is good for the amicable settlement of dispute. As this authority is specially designed for dispute pending before the Supreme Court, it can perform its work more efficiently, and beneficiary will not have to go any other court to ask for legal aid. The provision like short tenure, check on the misuse of the power, provision like short tenure and check on the use of fund by regular auditing of accounts prevent the chances of misuse of the power provided under this Act. Power and function of the Supreme Court Legal Service Authority are very wide. It shall have power and function to administer and implement the legal services program insofar as it relates to Supreme Court of India. For this purpose, it can take all such steps as may be necessary and to act in accordance with the direction issued by the central government from time to time. To receive and scrutinize application for legal services and to decide all questions as to the grant of or withdrawal of legal services. To maintain panel of advocates on record and of senior advocates in the Supreme Court for giving legal advice. To decide all matters relating to payment of honorarium, cost, charges and expenses of legal services to the advocates on record and to senior advocates of the Supreme Court. To prepare and submit written reports and statistical information in regard to the legal services program to the central authority. Next authority which is constituted under this Act is the State Legal Services Authority. It is not possible for the National Legal Services Authority to implement the provision of this Act without the assistance of other legal services authority. So every state is bound to constitute State Legal Services Authority in its territory. It shall consist of the Chief Justice of High Court, who shall be the patron-in-chief, a serving or retired judge of the High Court to be nominated by the Governor in consultation with the Chief Justice of the High Court, who shall be the executive chairman. Such number of other members possessing such experience and qualification as may be prescribed by the state government to be nominated by the government in consultation with the Chief Justice of the High Court. Representation of all the stakeholders engaged in the task of maintaining peace and harmony in legal services authority enhances the chances of settlement of dispute amicably and peacefully. That is why it consists of members from bar, bench, police department, legislative department, law colleges and social workers. The state authority will be duty bound to give effect to the policy and direction of the central authority laid down from time to time. The state authority give legal services to the needy person who satisfy the criteria laid down under this Act. It conducts Lok Adalat, including Lok Adalat for High Court cases. It also undertakes preventive and strategic legal aid programs. The short tenure of members of the committee puts check on the monopoly of few members on the exercise of power granted under it. The mandate of maintaining proper account and its auditing at regular interval eliminates the chances of misuse of funds by its member. The State Legal Services Authority coordinate the working of the other subsidiary authority at district level and give its report to the National Legal Services Authority. It also gives the direction given by the National Legal Service Authority to District Legal Service Authority. It acts as a managing link between District Legal Services Authority and the National Legal Services Authority. High Court Legal Services Authority is also another authority constituted under this Act. High Court Legal Services Authority provides for the free legal aid and amicable settlement of dispute in the cases pending before the High Court. It also provides for speedy disposal of dispute through Lok Adalat. It consists of a sitting judge of the High Court who shall be the chairman. Such number of other members possessing such experience and qualification as may be determined by regulation made by state authority to be nominated by the Chief Justice of the High Court. Like National and the State Legal Service Authority, it also provides for the appointment of members from the bench, bar and the social action group. Involvement of member from non-legal background is essential for the mediation and conciliation. Members of this committee are bound to maintain the accounts of the funds received and expenditure incurred on the implementation of provisions of this Act. A dispute comes from the High Court when parties to it were not satisfied from the Sessions Court decision. This type of dispute has covered a long journey of litigation before the courts, and it is in the interest of justice that there should be an end to litigation. So in such type of dispute, mediation, conciliation becomes very essential to put an end to the litigation. District Legal Service Authority. The District Legal Services Authority works at the district level. A district legal service authority consists of district judge, who shall be the chairman, such number of other members possessing such qualification and experience as may be prescribed by the state government, to be nominated by the government in consultation with the Chief Justice of the High Court. Like other legal service authority, it also provides for the members not only from the legal background but other background as well. So it makes easier for the body to understand the dispute of the parties and settle the dispute amicably. It is bound to do the function assigned to it by the State Legal Services Authority. It may coordinate the activities of the Taluka Service Committee and other legal services committees. It also organizes Lok Adalat within the district. Provision like small tenure of the members and the maintenance of accounts prevent the chances of malpractices in the Legal Services Authority. Many a times it happens that due to ignorance of the right or poverty, people fail to make proper legal representation in their cases, which leads to injustice. So it is in the interest of justice that needy people should get the free legal assistance at the grassroots level. Taluka Legal Services Authority works at the grassroots level. It is a useful mechanism to put an end to dispute at the initial stage, which will save the parties from unnecessary harassment if they fail to settle their dispute at a grassroots level. Legal Service Authorities Act has provided a list of people who are entitled to free legal aid under Section 12 of the Act. These are the people who can claim free legal aid under this Act, and free legal aid has been provided very broad meaning. It includes not only the free services of an advocate but also exemption from the court fees and the process charges. The people who are entitled for free legal aid under this Act are people of scheduled caste and scheduled tribe, a victim of trafficking in human being or a beggar, women and children. Here we need to understand one point, that women is entitled for free legal aid irrespective of her financial position. It doesn't matter what is her final position. It doesn't matter whether she can afford the legal services or not. If she is a woman, she is entitled for free legal aid under this Act. A person with disability, as defined under Person with Disabilities Act. A person under circumstances of undeserved want, such as being a victim of mass destruction, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disasters. An industrial worker or a person in custody. Custody includes custody in a protective home. So, if a person is a prisoner, if he is in judicial custody, then he is entitled for free legal aid, and no court fees and no advocate services will be charged from such person. A person in receipt of annual income less than Rs 9,000 or such other higher amount as may be prescribed by the state government. If the case is before a court other than the High Court and less than Rs 12,000 rupees or such other higher amount as may be prescribed by the state government if the case is before the Supreme Court. Person who satisfy any of the criteria mentioned in Section 12 will be entitled to free legal aid, provided that the concerned authority is satisfied that he has a prima facie case. An affidavit made by a person as to his income and his falling into any of the categories which makes him entitled to the free legal aid will be sufficient to make him available to the benefits provided under this Act. Supreme Court Middle Income Group Legal Aid Scheme. Supreme Court Middle Income Group Legal Aid Scheme. It was enacted to provide free legal aid to middle income group people. It has two-folded benefits. Firstly, it eliminates the chances of misrepresentation of the income by a middle income group to get the benefits of free legal aid in the Supreme Court, as now it is available to them as well. Secondly, it was realized that nowadays basic necessity of life has become so costly that middle income group hardly remains with any part of income after fulfilling basic needs to invest in their fight for justice. The criteria for providing free legal aid and regulation of proceeding under free legal representation is such that it entitles only those people who actually comes in the category of middle income group. There are adequate provision to prevent the advocate on record from doing its assigned work efficiently. It has also specifically provided that remuneration of advocate on record, which eliminates the chances of any dispute regarding the remuneration to be provided under these schemes. Lok Adalats. As we discussed earlier, that the objective of Legal Service Authority is twofolded. One is to provide free legal aid to those people who cannot afford it from their own earning, and secondly is to speedily dispose of the dispute, and for that Lok Adalat is the appropriate forum. Indian courts are overburdened with work and it takes years to settle the dispute before the formal court. As we know that justice delayed is justice denied, so need was felt for the constitution of alternate dispute resolution mechanism to settle the dispute speedily and amicably. The Lok Adalat is recognized as one of the alternate dispute resolution mechanism capable of settling the dispute speedily, cheaply and amicably. Its bench consists of members from legal and non-legal background. It is in a better position to understand the dispute of the parties and convincing them to arrive at a settlement. Experience of members from legal background help in understanding the fate of the case if brought before the formal forum, and people from a non-legal background help in convincing the members to come to a compromise or settlement. The Legal Service Authority can organize Lok Adalat at such interval, at such places, on such matters as they deem fit. A person shall not be qualified to be included in the Lok Adalat unless he is a member of a legal profession or a person of repute who is especially interested in the implementation of legal services schemes and programs, or an eminent social worker who is engaged in the upliftment of the weaker section of the society, particularly women, scheduled caste, scheduled tribe and children. The scope of Lok Adalat is very wide to include every possible petty offence and dispute. The Lok Adalat have no jurisdiction. But Lok Adalat has no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. The authority or committee organizing the Lok Adalat may, on receipt of an application from any one of the parties to matter referred above, refer such matter to the Lok Adalat for determination. No such matter is referred to Lok Adalat except after giving a reasonable opportunity of being heard to both the parties to dispute. When any case is referred to Lok Adalat, the Lok Adalat proceed to dispose of the case or matter and arrive at a compromise or settlement between the parties. Every Lok Adalat, while determining a dispute before it, will try to encourage the parties to come at compromise or settlement. It is guided by the principle of justice, good play and fairness. It is provided that when no award is made by the Lok Adalat on the ground that no compromise or settlement could be arrived at, then the case file and the records will be sent back to the court from which the case was referred to, and that court will start the proceeding before it from the stage from which that matter was referred to the Lok Adalat. It is also an accepted fact that justice hurried is justice buried. In order to save the time, it need not to follow the formal procedure, it need not to follow the Civil Procedure Code, Criminal Procedure Code, Evidence Act, and it is guided by the principle of natural justice. None of the parties can be forced to compromise before the Lok Adalat if the term of settlement fails to convince them. The award of Lok Adalat is final, so it put in check on the multiplicity of the cases. Once the parties of dispute agree to any settlement and they sign an agreement that they settle the dispute as per the settled agreement, then tomorrow they cannot file a case in any other forum, as we all know that there cannot be any appeal against the compromise decree. The provision of finality of award is a good provision to put an end to the litigation which is in the interest of justice. Power provided to Lok Adalat are sufficient to impart justice without compromising on its quality. Its award is given the status of decree, its proceeding is deemed to be a judicial proceeding. It is given the status of civil courts, having all the powers regarding summoning, discovery, inspection. On the top of all this, it has the power to specify its own procedure. Here we will discuss one very important case in which Supreme Court identified the importance of Lok Adalat. P.K. Thomas versus Thomas J.B. is a case in which Supreme Court identified, recognized and described the benefits of Lok Adalat. It's laid down that Lok Adalat is an old forum of adjudicating system prevailing in ancient time. Its validity has not been taken away even in modern days. The word Lok Adalat means people's court. This system is based on Gandhian principle. It is one of the components of alternate dispute resolution. As the Indian courts are overburdened with the backlog of cases and involve a lengthy, expensive and tedious process, the court takes years together to settle even petty cases. Lok Adalat therefore provides alternate device for expeditious and inexpensive justice. In Lok Adalat proceeding, there are no victor and no loser, and thus no enmity. Experience of Lok Adalat as an alternate dispute resolution. Experiment of Lok Adalat as an alternate mode of dispute settlement has come to be accepted in India as a viable, economic, efficient and informal one. There is no court fees, and if court fees has already been paid and after that matter is brought before the Lok Adalat and has been settled before the Lok Adalat, then fees which has already been paid will be refunded to the parties. The basic feature of Lok Adalat is that it has procedural flexibility and speedy resolution of dispute. There is no strict application of procedural law like Civil Procedure Code and Evidence Act while addressing the claim by the Lok Adalat. The parties to dispute can directly interact with the judge through their counsel, which is not possible in regular court of law. The award of Lok Adalat is binding on the parties and it has the status of decree of civil suit and it is not appealable. So, it removes the delay in settlement of dispute finally. Another very important case we will discuss here, that is State of West Bengal versus Union of India. It is a case in which Supreme Court discussed the relationship between section 12 and reference of the matters before the Lok Adalat. The matter which was brought before the notice of the court was, if a person wants to get his dispute settled through Lok Adalat, is it necessary that he should be entitled to free legal aid as laid down under section 12? And court said, if parties to dispute themselves refer to the court, that their dispute should be referred to Lok Adalat, or if the court feels that the matter which is pending before it can be settled amicably through Lok Adalat, then he can refer the matter to the Lok Adalat, and in such situation it is not at all necessary that the parties to the dispute should be entitled to free legal aid as provided under section 12 of the Legal Services Authorities Act. Whereas, if National Legal Service Authority or any other legal services authority constituted under this act refers the matter to the Lok Adalat or to the court, then it is mandatory that that person should be entitled to free legal aid as mentioned under section 12, which means that he should be a person who falls in the category of people entitled to free legal aid as per the provision of section 12 of the Legal Services Authorities Act. Now we would discuss another form of Lok Adalat, which is known as permanent Lok Adalat. Many a times it has been seen that the cases in which government employees are involved takes long to dispose of because government employees doesn't have personal interest in the dispute to be settled down. Moreover, they have so many other things to do, and it's not easy for them to take off from the government job and come before the court again and again. And moreover, if they do so, then again it affects the society at large, because all those people who could have got their work done from that public post is vacant for the time being, because that officer has gone before the court to appear before the court in any dispute in which that office is involved in. So, looking at the problem of delay in settlement of dispute in which government employees are concerned and involved, permanent Lok Adalat was constituted. In the permanent Lok Adalat, only those dispute which relates to public utility and public services can be brought. Every permanent Lok Adalat established for an area consists of a person who is or has been a district judge or additional district judge or has held judicial office higher in rank than that of the district judge shall be the chairman of the permanent Lok Adalat. Two other persons having adequate experience in public utility services. Now we need to understand that who can make an application before the Permanent Lok Adalat. Any party to the dispute, before the matter has been brought forth any court, he can make an application before the Permanent Lok Adalat to get his dispute settled before the Lok Adalat. It does not has jurisdiction in respect of any matter relating to an offence not compoundable by any law. It also has no jurisdiction in the matter where the value of the property in dispute exceed rupees 10 lakhs. The central government may by notification increase the limit of 10 lakh rupees specified here in consultation with the central authority. Provision like appointment of member from legal and non-legal background is a very helpful provision because people from a legal background will help the parties in understanding the fate of their case in the legal term, whereas members who are from non-legal background will help them, encourage them in settling the dispute amicably. It has conciliatory as well as adjudicatory powers, which means at the first instance the members of the Permanent Lok Adalat, which constitute its body, will help the parties to dispute to settle the dispute amicably. They will provide them conciliation to settle their dispute. But if the parties fail to settle the matter amicably, then Permanent Lok Adalat can exercise its adjudicatory function, which means it will settle the dispute on the basis of matter which has been brought before it and can pass an award which will be given the status of decree. If the parties to dispute settle the dispute through amicable means of settlement and by the help of compromise, then there will be no appeal against such order. But if the Permanent Lok Adalat has settled the dispute by adjudicatory power, then it is not a compromising decree. This act provides certain residuary power to the authorities to make rules to cope up with the changing needs of the society. For the administration of justice, it is very necessary that justice provider should have sufficient power to administer justice and immunity from action for anything done in good faith. Legal Services Authorities Act has provided sufficient power to its officer that if anything has been done by him in the discharge of his official duty, then he cannot be made liable for it. The provision of this act has the overriding effect. If there is any provision which comes in conflict with any of the provision of this act, then the provision of this act will have overriding effect. As the rules and regulation have to pass very strict procedure for approval which eliminates the chances of corruption, misconduct or any other malpractice. It can be said that this act is a golden gift to the people because as we discussed earlier that there are certain impediments, certain hardship which are restraining people from coming before the court and accessing the justice. To conclude, I would like to say that this National Legal Service Authority is a golden gift for the people. As we discussed in the beginning that there are certain hindrances which comes in the way of access to justice. One of such hindrance is the delay in disposal of dispute. This act provides for the organization of Lok Adalat and Permanent Lok Adalat which settle the dispute with speed. Moreover, as it settles the dispute by compromise, there cannot be any appeal against such award and it puts an end to the multiplicity of the cases. Another hindrance which we discussed in the beginning was the poverty. If a person doesn't have means to represent his case before the court or hire the services of an advocate, it generally restrains him from coming before the court. As this act provides for free legal aid to those people who are in need of it, this is a very helpful piece of legislature because now people need not to stop from coming before the court just because the reason they don't have financial resources to pay the fees of an advocate or to pay the charges of the court. In end, I would like to say that access to justice has actually been brought at the grassroots level at the doorstep by the help of this provision.